Well, good morning, everyone, and welcome to the Canadian Northern Corridor Research Program webinar series. Thanks for joining us today. Before we begin, I'd like to acknowledge that the University of Calgary is on the traditional territories of the people of the Treaty 7 region in southern Alberta. The city of Calgary is also home to the Métis Nation of Alberta Region 3. I'm Marcia Nelson, an School of Public Policy, and I am happy to be your moderator today. This series is part of the Canadian Northern Corridor Research Program at the School of Public Policy, which is exploring this ambitious concept. And you can find out more about the project by visiting www.canada. Today, we're going to dive into a paper written by David Wright called Cross Canada Infrastructure Corridor, the Rights of Indigenous Peoples and Meaningful Consultation. We'll have plenty of time for questions after the presentation, but please do submit your questions as you think of them as they pop up by clicking on the Q&A icon at the bottom of your screen. At this point, I'd like to welcome David Wright, Assistant Professor, Faculty of Law from the University of Calgary. And I think now we'll just turn it over to David for the presentation.
Well, good morning, everybody, and thanks, Marcia, for the kind introduction. Before we really get going, let me just share my screen. And I will assume that everyone can see that just fine. So welcome to this morning's webinar, and it's wonderful to be with you today. Of course, like everything else in today's world, it'd be better if we were together in person, but we're making do, and credit to the School of Public Policy for making do. Also credit to the School of Public Policy for leading the research on this topic focused on this extremely ambitious concept. I find the topic particularly interesting as I've had the privilege of living in all three territories across Canada's north, first as a youth in the Yukon, and then in the Northwest Territories and Nunavut as an adult. So I come at this from a scholarly perspective, but also as a lawyer and policy advisor who has worked in this area over the years. One key takeaway from all my past work in this space is encapsulated by something that was said to me by an astute leader in this area. And he said, you know what they say, Dave? Well, once you've seen one Indigenous community, you've seen one Indigenous community. And so throughout today, you'll hear a number of comments from me pointing to how much diversity there is across the legal landscape and across the Indigenous communities in Canada today. So first, to kick things off, a roadmap. This will be about 20-25 minutes. I'll be going through a lot of complicated concepts fairly quickly, but we should have lots of time in the Q&A to dive deeper if there's a desire. So first, I'll just provide a succinct introduction to the legal landscape of Indigenous territories in today's Canada. Then we'll walk through the basics of the duty to consult, which I'm sure many of you have heard of. And then we'll zoom in on the concept of meaningful consultation, then relate that to the corridor concept, and then finally a few concluding thoughts and then the Q&A. So it's no secret and no surprise that there are perceived constraints on getting Canadian commodities to global markets, and that has led to renewed interest in this cross-Canada northern corridor, which was first floated in the 1960s and 70s, as you may know, especially those who have watched the last two webinars of this type. But what's changed a lot since the 1960s and 70s is the law as it pertains to Indigenous peoples living in Canada today. So we've seen resistance to a number of these linear infrastructure projects. Some of that resistance is from Indigenous communities. Indeed, some support is from Indigenous communities as well. And in some cases, that is manifested as successful legal challenges to specific project approvals. Courts have quashed project approvals, most notably in relation to the Northern Gateway project and the Trans Mountain project before it was then reapproved. So put succinctly, the tensions have been running really quite high. So in today's presentation, I'm going to describe at a high level the legal context through which this tension flows, and a particular focus will be on the duty to consult and this concept of meaningful consultation. So with some hesitation about overgeneralizing, I'll begin with an overview of three different legal contexts, that of historical treaties, then modern treaties, and non-treaty areas in Canada today. By way of context, though, as some of you may know, these linear projects pass through many different Indigenous communities and traditional territories. So for example, in the Trans Mountain context, it's estimated that up to 120 Indigenous communities were potentially impacted along that route, or at least involved in that process. And that number was 180 in relation to the Energy East pipeline process. So before getting to all that, though, I'll just quickly touch on what the corridor concept is. Again, some of you may have picked this up from the readings or past webinars, but it is conceived as a 7,000 kilometer corridor in Canada's north and near north that would establish an east to west right-of-way for road, rail, pipeline, electrical transmission, and communication networks, and connect with existing networks in southern Canada. So this is just an artistic rendition of the corridor, and it is simply that. I think there is a lot to be sorted out yet, and that'll come through in the rest of my presentation. Okay, so turning first to historic treaties. I won't go into great detail here, although I encourage you all to do much reading on these topics as they're tremendously important in Canada today. But what's important to know for our present purposes is that before and after Confederation, Canada engaged in much treaty making. This began with the treaties of peace and neutrality and the peace and friendship treaties in the early 1700s, which you see on the right of your screen down in Eastern Canada. And it ended with a number of treaties, the last of which was Treaty 11, signed in 1921, covering parts of all three of today's territories. So the treaty rights stemming from historical treaties can be procedural or substantive in nature. And so, for example, a treaty may recognize substantive rights to hunting and fishing. It's important to note, though, that these rights, even today, are still often contested. So it may be well understood that a right exists, but the specific content of that right may not be all that clear. A key distinction in these historical treaties for the purposes of linear infrastructure projects is whether or not they include land ceding provisions. That was the case in most of the, or all of the numbered treaties, but not the case in some of the other, or all of the other historical treaties. In any event, and regardless of what's set out in the treaty, consultation obligations on the part of the Crown do exist in all these contexts, as clarified in the Mackenzie case in 2005. We'll get into what that means in a few minutes. But first, we will turn to the modern treaty context. So it may come as a surprise to some viewers that Canada is still very much in the business of treaty making. And this restarted following the landmark case of Calder in the Nisga'a context in British Columbia in 1973. There are now 26 modern treaties covering different parts of Canada, primarily across the territories, but also in parts of British Columbia and Quebec and Labrador. Some of these treaties are not your grandfather's treaties, if you will, to adopt an Oldsmobile ad phrase. They're modern, detailed, sophisticated, comprehensive legal agreements, and they typically include chapters on wildlife management, environmental assessment, heritage, resources, parks, expropriation, economic development, and so on. And in many cases, explicit consultation obligations are set out in the treaties, although as per case law, those consultation obligations are not exhaustive. There may be consultation obligations beyond the terms of the treaty. It may be interesting for some of you to note that some of these treaties were born out of, or the impetus for some of these treaties was a pipeline project, i.e. the Mackenzie Valley Pipeline Project proposed back in the 60s and 70s, reviewed by the Berger Inquiry. And so in some things, what's old is new again in this context. And as some of you may also know, there was indeed a pipeline approved through the Mackenzie Valley in the form of the Mackenzie Gas Project, approved in 2011, but canceled in 2017. Finally, we have non-treaty areas, and there are several parts of Canada that do not have treaties, especially in British Columbia. And so in these contexts, there are asserted rights and title that are still being clarified and often negotiated, although those negotiations have not gone particularly well. So here is one depiction of the context in British Columbia. What's important to understand or to see is that this is what it looks like across the country. And so if this looks complicated, it's because it is. This map is a little bit dated, but it still does a reasonably good job of depicting the different legal contexts across the country. It's tremendously complex and diverse. And this is really a view into the legal landscape through which the corridor would be trying to navigate. And one last map. This is a depiction of First Nations community across Canada, roughly 630 First Nations communities. This does not include Inuit communities or Métis communities, but again, it does a good job, or it's helpful in understanding the number and diversity of Indigenous communities. And of course, these are just pinpoint locations of specific communities, but the traditional territories and treaty areas of these different communities are much more geographically expansive, and rights and title may include large swaths of land. So where is all this coming from a legal perspective? Well, it's well articulated by leading Indigenous law scholar John Burroughs, who writes, Aboriginal rights exist because they are derived from Aboriginal laws, governance, practices, customs, and traditions. They exist in Canadian law not as a result of governmental recognition, but because they were not extinguished upon British or French assertion of sovereignty or establishment of governmental authority in what is now Canada. Aboriginal rights are therefore unlike other forms of rights that exist in Canadian society. Aboriginal rights are part of Canadian common law and Canadian constitutional law, even though they did not arise under these regimes. So looking further into the Canadian legal context, it's well known that these rights were constitutionalized in 1982. So they're entrenched and protected under Section 35 of the Constitution Act, which reads, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Now, the succinctness of this text belies its complexity, because at the time of negotiating and drafting it, it was not precisely clear what existing Aboriginal and treaty rights include. And in many cases, the content of these rights, as I said earlier, are still not clear. And this may include what's known as Aboriginal title to land. And it may also include Aboriginal rights. Typical examples folks think of are fishing, hunting, and trapping rights, although there may be more, and those are still being clarified. So the clarifying of the content of these rights is still ongoing, and often, unfortunately, involves or requires Indigenous communities to turn to the courts. And so often Indigenous communities are engaged in long, expensive processes to have these rights recognized, typically by the courts, but sometimes through treaty, i.e. through negotiation, and sometimes by a mix of statute. Sometimes by statute or a mix of all of these. Much interpretation was left to the courts. So when this text was landed on back in 1982, it was because there was not wide political agreement of what the text should say. And then there were a series of constitutional conferences that did not really generate any further clarity in the years to follow. But a helpful quote comes from the 1996 landmark decision of Vanderpeet. We won't go into that case in detail, but Justice Lemaire wrote the following, which is helpful in this context. The doctrine of Aboriginal rights exists and is recognized and affirmed by Section 35, sub 1, because of one simple fact. When Europeans arrived in North America, Aboriginal peoples were already here, living in communities on the land and participating in distinctive cultures as they had done for centuries. It is this fact, and this fact above all others, which separates Aboriginal people from other minority groups in Canadian societies and which mandates their specific legal and now constitutional status. So that means there's a whole lot that follows from that, and we don't have the time to go into great detail on it. But one of the things this means is that there are significant consultation obligations on the part of the Crown. So we'll focus the rest of the presentation on this notion of the duty to consult and the specific concept of meaningful consultation. So as many of you may know, the duty to consult has three primary elements to be triggered. So in the landmark decision of Haida in 2004, this was percolating in the case law for years before that, but the duty to consult, as we now know it, was really clarified and set out initially in the landmark case of Haida in 2004, where the Supreme Court clarified that in situations where there is Crown conduct, and that Crown conduct has the potential to adversely impact Indigenous rights, and there is the existence of potential or established Aboriginal or treaty rights, then the duty to consult is triggered. Now we have 16, almost 17 years of case law since then, where the contours of this legal duty and the legal doctrine have been clarified. So here's how it works in practice. So turning to the court applies what's known as a spectrum approach, which takes into account the seriousness of the adverse impact and the strength of the claim to rights. So turning to the middle box on your screen, essentially the more seriousness, the potential adverse impact, the more consultation that is required. But also the stronger the strength of the claim to the right, or if there is an established right, then also more consultation is required by the Crown. And so the Federal Court of Appeal has, so it's the second highest level of court in the land, has offered a few helpful articulations of this in recent years, now that we're sitting on a relatively mature body of case law. And they said several years ago that the duty to consult is firmly established, but its contours can be imprecise. But more recently in the Coldwater case, that's the upholding of the reapproval of the Trans Mountain Pipeline case, the Federal Court of Appeal said the case law is replete with indicia of what constitutes or satisfies this concept of meaningful consultation. So this is a helpful thing for those interested in pursuing the corridor concept, because we have this modern, mature body of case law that is replete with indicia. So we're going to look at that in detail in a minute. Several of the cases that shed light on this is not an exhaustive list, but a helpful one and you may want to go and read these cases at some point, or at least the head notes of them. But we have the Gatsala case from 2016, that's the quashing of the Northern Gateway pipeline approval. Of the Clyde River case from 2017, that's dealing with seismic testing off of Baffin Island. Chippewas of the Thames dealing with Enbridge Line 9, the Ontario context. Tsleil-Waututh, that's the quashing of the Trans Mountain approval, the initial one, and then Coldwater, which was just released earlier this year, upholding the reapproval of the Trans Mountain Pipeline. And again, these cases are where we look to understand, first of all, the duty to consult in its now mature form, and also what constitutes meaningful consultation in Canadian law today. So what is it? What does it look like? Well, here, I've tried to boil down, you'll see this in the paper, the indicia as set out by the courts over the years and sort of restated in increasingly clear format in recent years. So it typically involves early notice. It includes good faith efforts by both parties, that's the Crown and Indigenous communities, meaningful two-way dialogue, often participation funding. We know that the duty can be the consultation activities can be delegated to project proponents, but the ultimate duty will always remain with the Crown. The idea is to focus on, there's a need to focus on specific concerns raised by Indigenous communities. It can't be just talking in generalities. There is a need for the Crown to respond substantively to information requests, and in some contexts that may require translation into Indigenous languages. That was the case in the Clyde River context in Nunavut. This means there needs to be demonstrable integration of Indigenous communities' concerns. It may give rise to a duty to accommodate where the rights may be affected in a significant way. That often takes the form, for example, in a specific project context of project approval conditions, could be a route change as well. And the government officials, especially in later stages, must be empowered to dialogue on all aspects of genuine interest to the affected or potentially affected Indigenous communities. And so, for example, in the Trans Mountain context, as some of you may know, former Supreme Court Justice Frank Iacobucci was appointed by the government to essentially represent the Crown and ensure that this meaningful dialogue was happening, and he was empowered to make decisions in that context. Process also does not, though, give Indigenous communities a veto. There is no, quote, duty to agree. So just a few other sort of high-level points. These are less indicia and more governance. The case law has been relatively clear that if the duty to consult is not met, then a project cannot be in the public interest. So consultation obligations on the part of the Crown must be met before a project can be deemed to be in the public interest. We'll talk about, what the corridor means in a legal sense. Is it a project? Is it something else? We'll talk about that in just a minute as we wrap up. And also, though, the rights and interests of Indigenous communities can be balanced against other interests, i.e., other elements of a public interest determination. The duty to consult must be discharged before the government proceeds with any approval or decision that could adversely affect Aboriginal or treaty rights. But it is up to the government to set up regulatory schemes to address the procedural requirements appropriate to different problems at different stages, and so on. So what that means essentially is the government has a significant amount of latitude in how they go about setting up a system to fulfill its consultation obligations, and courts have tended to defer to whatever systems the courts or the government has set up. But overall, a key takeaway here, and going back to the complicated map on the bottom right of your screen, is that the extent and content of the duty to consult is fact and context specific. So it hinges on those specific potentially adversely affected rights, the strength of that claim, if it's an asserted rights context, or it may be an established rights context, and the seriousness of the potential infringement. And that's all in relation to the different types of projects or Crown decisions that are at issue. So the different legal contexts that we talked about, historical treaties, modern treaties, non-treaties, are simply starting points, and then one would apply these indicia from the case law to each context in relation to whatever Crown action is being contemplated. So to synthesize a bit, in the last few minutes here, we do have much guidance that governments could follow to meet the standard of meaningful consultation in pursuit of a corridor concept. But the concept and proponents of the concept, especially government, needs to appreciate the great diversity that would require a sensitive, respectful, context-specific approach. So, for example, in a non-treaty context, there would have to be significant understanding of the nature of the rights being asserted, and this could be particularly consequential if there's a strong claim, for example, to Aboriginal title, i.e. land rights. In a historical treaty context, there would have to be understanding of the relevant treaty rights, as well as an appreciation that the treaty rights may themselves be unclear, and there may be some work to do to clarify and resolve disputes around rights in those contexts. And in a modern treaty context, the text of the treaty really is the starting point and explicit consultation obligations, but there may be rights, interests, and consultation obligations that need to be considered in addition to the text of the treaty, or at least consultation requirements. So recall that spectrum approach. Essentially, in each Indigenous community context along any type of corridor route, there would have to be deep understanding of the legal context associated and potential impacts that the corridor and ensuing projects may bring. So there's a key tension here that you may be sensing, and that is between this context-specific nature of the duty to consult that flows from the specific Indigenous rights and interests in relation to a specific project or initiative, and then the relatively abstract linear nature of the corridor. And so it'd be very difficult to anticipate all the specific potential impacts and then consult on all of them. So if the corridor is pursued in this sort of envelope approach, it would still be very difficult to predict all the potential impacts of all the potential projects. Adding to that, it's also difficult to predict which specific projects private actors would pursue and where they sit in time, and recognizing that some aspects of the project may change in the time between any formal legal establishment of corridor and the actual pursuit of the project. In any case, there is basically no doubt that each specific project would then trigger the duty to consult all over again, and consultation would be required. Would that consultation be able to draw on the learnings of some preliminary work on the corridor? Perhaps, for example, there could be traditional land use studies and understanding of potential impacts that could be drawn on if done today and used tomorrow. But in any event, the consultation obligations would be triggered in relation to each specific new project, because again, the Crown is making a specific decision to review and approve those projects. So just a couple high-level points before we wrap up, almost at time here. A lot of the specifics of the duty to consult and what meaningful consultation will mean depends on the specific legal nature of the corridor. And I appreciate that that's still being sort of thought through. And I see a governance paper was published just a few days ago that goes into different options here. So some, what could that look like? It could be that the project is broken up into smaller segments. Maybe that makes consultation activities a little more manageable. From an institutional perspective, perhaps this looks like a Berger Inquiry 2.0, so a specialized commission set up to look at this and to engage with Indigenous communities at a high level and at a specific level. A lot of folks have strong opinions on the Impact Assessment Act, but there is a very helpful tool in there under Section 93, I believe, to conduct regional assessments. And then the outcomes of those regional assessments must be used in ensuing project-specific assessments. So under whatever institutional approach is taken, one of the things they could do is have powers to conduct a regional assessment under that act in anticipation of future projects. There is increasing activity in the form of Indigenous-led assessments that could be part of this. And overall, there at an even higher level, there could be or ought to be a parallel process to clarify Indigenous rights, interests, and title. And those are the issues that many Indigenous communities are most interested in, as well as jurisdiction and self-determination and nation building. Second last slide before we turn to Q&A. It's important to be aware of the broader changes in federal law and policy because they are relevant in pursuit of the corridor. The nation-to-nation relationship between Indigenous nations and governments is changing, it's evolving, and it's evolving fairly quickly. So at the federal level, we see, of course, the Truth and Reconciliation Commission's calls to action in June 2015. Soon after the federal election in 2015, there was a call for this renewed nation-to-nation relationship. The federal government has also voiced its, quote, full support for the United Nations Declaration on the Rights of Indigenous People, and we expect so-called UNDRIP implementation legislation to come at some point. Well, we thought it'd be here by now, but presumably in 2021 it will be tabled. There's also a review of law and policies happening. The federal government in July 2017 released the principles respecting the government of Canada's relationship with Indigenous peoples. There's also this recognition and implementation of rights framework that has been published. We won't go into any great detail, and that one actually has been paused. But these sort of give you a sense of how quickly the federal government law and policy landscape is changing. And of course, we have the new Impact Assessment Act and the Canada Energy Regulator Act. What all of this may underscore is a trend toward consent as the standard, and that the duty to consult, as we know it, may be sort of the floor. It's the minimum required, but in the interest of a nation-to-nation relationship, in pursuit of reconciliation, whatever that means to different people, there is a need for a new approach and at least an aim to secure consent of Indigenous communities as part of meaningful nation-to-nation dialogue. So just a few concluding points. Meaningful consultation standard is relatively clear in the case law, and the duty to consult and that meaningful consultation concept is inherently context specific, whereas the corridor concept is relatively abstract and it's likely to implicate many communities, so that we have this tension when you overlay the context specific duty to consult legal doctrine with this relatively abstract and linear nature of the corridor context. Overall, though, to do a full assessment, a full legal analysis, we do need more details on the legal nature of the corridor. Is it just a right-of-way? Does it also include some route clearing? When would the first projects come along? And so on. So what that means is this notion of pre-approval of the corridor may be at odds with some of the legal realities. So you could probably lay some groundwork and again do some of the preliminary research, but the duty to consult is no doubt going to be triggered on a project-specific basis. Overall, and this is not news, A transactional efficiencies-based mindset is unlikely to work. That is, if there is pursuit of the corridor concept and engagement with Indigenous communities, this notion of a transactional, is this a more efficient way of doing things, is unlikely to work and is unlikely to build the types of relationships that are needed to see this through. So overall, what that means is that consultation on the corridor is unlikely to be a shortcut when it comes to the full body of consultation that would happen on the corridor and then specific projects, but it could achieve some coherence, and there could be some relationship building in service of Indigenous nation building, for example, that could be helpful for the long term on all sides. But overall, it is important that many Indigenous communities are primarily concerned with self-determination, securing jurisdiction, i.e. self-governance, and nation building, and addressing community challenges and priorities. So with that, lots to chew on, and I'll look forward to the question and answer period that will start now.
Thank you so much, David. That was terrific. And thank you as well for your paper, because I found it to be probably the most accessible and kind of clear discussion of this topic that I've engaged with in a long time. So I really enjoyed it. I think I want to start by kind of quoting some of your own words back to you. And that is, you write that complex problems are seldom solved through simple responses. And I think, it speaks volumes in relation to this corridor concept, because many proponents of a corridor concept are looking to it to simplify what many have viewed to become a very complex, time-consuming, uncertain regulatory process. And I think what you've said is, a corridor is a very abstract concept, and you need to embrace appropriate consultation with very specific projects. So ultimately, I think what you've said is you can expect significant consultation being required to establish the corridor, and then subsequently additional significant consultation on specific projects. So do you think the rationale holds up?
That's sort of the ultimate $64 billion question, isn't it? So as I tried to say in the presentation, the logic or rationale behind the core, first of all, it's too early to pass judgment. And this research initiative is doing the right thing by taking evidence-based baby steps to see if this is worthwhile at all, so that everyone can approach it with eyes wide open. What's unfortunate is it gets batted about as a sort of magic bullet without understanding the complexities. So to the extent that this can lay the groundwork for some of the research and understanding that's needed along a potential route, it certainly makes sense. And again, recognizing that in today's day and age, the interest of a lot of Indigenous communities and the stated interests of governments is to build on that nation-nation relationship, move together towards reconciliation, whatever that is. And I use that term with hesitation because it's so loaded. And I think the corridor concept could help. I mean, another way to put this is the duty to consult has not been going very well, as everyone has seen in the legal challenges. And so one could reasonably argue that something needs to change. And so this sort of landscape scale, comprehensive, early stage consultation and engagement on corridor concept could help that. But overall, if you were to put this in Venn diagrams, the amount of consultation required beyond consulting on the initial corridor is certainly a circle much larger than that body of corridor consultation. And so again, that efficiency mindset is probably not the right one to be adopting and approaching this.
Great. Well, you just mentioned that meaningful consultation really is at the heart of success in relation to these major infrastructure projects. We certainly saw meaningful consultation, or lack thereof, was at the heart of the Trans Mountain court cases, where the Federal Court of Appeal basically quashed the approval that Trans Mountain had because it was deemed to have not had sufficient meaningful consultation. And in your presentation, you showed us sort of this progression of cases where meaningful consultation was, specifically being fleshed out and delineated. And I actually thought your paper gave probably the clearest description of what meaningful consultation is that I've ever seen. So why do you think government struggles so much with this? What aren't they learning?
Yeah, good question again. So, I mean, thanks for the credit, but the credit, I'll pass it a little bit and say the courts have improved as well. So the courts have, the judgments of the courts in general, any area of law, have been increasingly sort of clear and accessible and relatively easy to digest, so relative to older decisions. And so on this front, there have been increasingly clear statements on, what constitutes meaningful consultation. It's difficult in practice. Government is not particularly well set up to have meaningful, deep discussions with multiple Indigenous communities. And this is the inherent challenge of a linear infrastructure project, right? There are so many Indigenous communities that may be potentially affected and then, have to be engaged. And government's not particularly well set up for that, right? So the government is set up to distribute government officials to these different contexts, but those government officials don't always have decision-making power, not sufficiently senior in the ranks to engage in the nation-to-nation dialogue that many Indigenous communities are interested in. And so this gets into a broader discussion, but we have these indicia, but they are difficult for the government to implement because of the way that government is set up. And so, for example, in the Trans Mountain, the quashing of the Trans Mountain decision in Tsleil-Waututh, the court said very plainly, missing was, this is kind of Valentine's Day type language, was the special someone who could engage in meaningful dialogue with these Indigenous communities. So that the government went to school on that and did improve, and the reapproval was upheld. But it's hard to replicate that level of consultation over this number of Indigenous communities. And so that's where perhaps a segment by segment approach to the corridor concept may be a little bit more achievable or at least fathomable.
Well, one of our questioners in the Q&A has posed the question, is there not an opportunity to basically pick, the highest impact of all the proposed projects, use that as the sort of the forefront of the review, and then of course subsequently other projects could be covered in that consultation. Of course, he raises the concern of cumulative impacts potentially being a concern, but is that an approach that we might consider?
Yeah, so if I understand the question correctly, and this comes up in the paper, the government would be wise to err on the side of so-called deep consultation, and which is in practice essentially meaningful consultation. And so while, again, thinking back to that spectrum approach, we know that if there's sort of a weak asserted right and a not so serious potential impact, then the duty to consult may not be meaningful consultation, or the obligation may not be meaningful consultation. It could just be notice and sort of keeping a party informed. In the corridor context, the government would be wise to err on the side of deeper consultation, i.e. meaningful consultation, so that they are more likely to be hitting the relevant standard. So that's that part of things. What's challenging, though, again, is predicting all the potential impacts. Now, you could try this, right? But, think of potential spills from a pipeline, for example, potential severe weather impacts from a power line, habitat fracturing or fragmentation, rather, from roads and so on. You could try to pack all those into this envelope approach and consult on them. But without real project proposals on the table, it will be difficult to deeply engage in what those potential impacts are going to be. Again, recognizing that time will likely pass and those impacts may change, and the specific project features may change depending on economics and materials and so on.
David, could you comment specifically on the complexities that would be related to consultation on unceded territories? Is it reasonable to expect that meaningful consultation is more complex when you're crossing unceded land?
Um, it's hard to generalize to say whether it's more complex on unceded land, but a key complexity there is that it's not an established, quote, Aboriginal right, not established title. So there has to be an exchange of information, dialogue between the Crown and the Indigenous community with respect to what the asserted right is, what the content of that right is, and then how that can be potentially affected. And so that level of uncertainty does make it relatively complicated. That complexity exists in treaty context too, though, again, because the content of the specific right is not always delineated. And so what you've got here is a tension between this need and desire to clarify Indigenous rights and title across unceded areas and areas of non-treaty areas, with this desire for certainty on the part of proponents and so on. And so without resolving those prior issues and clarifying jurisdiction, rights, title, and so on, it's harder to get these projects through. And so this is a problem that's not a problem. This is a reality in Canada that has existed for decades, and it's politically unpopular to resolve these long-standing issues, and they will continue to come up until they're resolved.
Well, one of our audience members basically makes the point that for every piece of linear infrastructure, a whole host of considerations come into play. You need to engage with all the affected potential stakeholders, including Indigenous groups. So, it's complex for every one of these. So apart from the scale of this type of an endeavor, is there something unique to this that makes it challenging? Is it the fact that it's abstract and not specific? Is that the main challenge?
Yeah, I think you mean in relation to the corridor itself. Yeah, and again, it's a little too early, but it is, I mean, so there's sort of two dimensions. There's the abstract nature and the linear dimension. And so the question is a good one. Yes, the complexities associated with a linear project are kind of common, if you will. It's the abstract nature of the corridor that makes it even more difficult and difficult to fulfill all consultation obligations. Can you do it? Yes. I mean, one of the key points of the paper is that there's completely a pathway of the possible here. It's just complex and sort of riddled with hurdles or opportunities, perhaps, if you want to cast it more positively. But because of the abstract nature, it will be difficult to fully discharge consultation obligations, for all projects that may fall within the corridor.
One of the areas that you raise, I think just a great discussion on, is the duty to consult in your paper. And you talk about the duty to consult does not equal consent. So Indigenous organizations don't have a veto on projects, that the duty to consult guarantees a process, not the result. And you've also said that this is one of the areas where there's not complete certainty, that things are still changing. There's not the same clarity around this concept. So is it your expectation that we'll continue to see challenges to projects based on the duty of to consult, or how do you see that concept evolving?
A couple things to say. So first of all, will there be more legal challenges? Yes, of course there will be. That's virtually a certainty. What I'm pointing at there is that there is an evolution in Canadian law and policy, particularly flowing from the government, perhaps not flowing to the same extent from the courts, toward a standard of consent. What that means, again, is a little bit complicated. So that the federal, and some folks, especially proponents of the corridor concept, would be heartened by the fact that the federal government's interpretation of consent is to just strive to achieve consent, not that consent must be obtained. And so this is where you get this tension, and you see this in the Trans Mountain context right now, where a project or a corridor could theoretically and legally be approved over the the resistance or wishes of an Indigenous community. And so one helpful example of that in today's context is the new Federal Impact Assessment Act. It's really predicated on that same legal foundation and same premise where as long as the duty to consult is satisfied, a project can be deemed to be in the public interest and approved. How much that will shift in coming years is very difficult to say, but while there is this drift towards meaningful consultation and the goal of securing consent of Indigenous communities, it is still not the legal standard, and that is subject to much, as you might imagine, criticism and frustration of many Indigenous communities.
Can I ask two location-specific questions?
Sure.
The first being, how does this relate to the devolution, or how does this process relate to the devolution in the Northwest Territories? That's one.
Sure.
And the second being, how does this concept or process relate to Nunavut and some of the Inuit IQ principles that apply there?
Okay, wow, we're getting quite technical now. Good questions. So a couple things. First of all, I think part of that question is, who is the Crown? Who has the duty to consult? The consultation obligations belong with whatever Crown is engaged in the action, typically some kind of Crown decision that has the potential to adversely affect the Indigenous rights. There's case law on this, and so the territorial governments can have consultation obligations, and obviously the federal government has consultation obligations. So to the extent that the territorial government is a decision maker, as they are often in the devolution context, they will have the consultation obligations. To the extent that the federal government is the decision maker, and I recognize viewers who haven't read up the other papers or viewed the other webinars in this series may want to know that I think the central premise of this initiative, and I'm kind of on the outside just doing some research here, but the central premise is that the federal government has a lead organizing role in pursuit of the corridor concept. So sticking with the NWT for a second, and back to the segment by segment approach, one thing I hope would come up in Q&A is there already is a linear infrastructure project all the way up the Mackenzie Valley. Right, and that is, it was going to be the Mackenzie Valley Pipeline, Mackenzie Gas Project that was mothballed, but there is the Mackenzie Valley fiber optic line. And there is appetite, as I understand it, for Mackenzie Valley Highway to go all the way to connect Inuvik, or perhaps Sigachik, and Norman Wells. They're currently constructing it from Wrigley to Norman Wells. So in that context, you would have some kind of institutional arrangement whereby the Crown is represented by whatever single body is overseeing the review and approval context, and then the specific decisions would be made. In the Nunavut context, it's a good question, and this is where the government and Indigenous communities can collaborate to create the process that is fit for purpose. The extent to which Inuit IQ could be integrated into that is significant. There's really no limits. So in that context, one would expect the government of Nunavut, the Inuit organizations under the Nunavut Land Claims Agreement, and the federal government to be cooperating to, have a joint statement of principles and approaches for what will inform that aspect of the assessment of the corridor. I know that's a long answer. Those are huge questions, all to be determined.
Yeah. So here's another big question, and I think it'll take us back to your first comment. When you've seen one Indigenous community, you've seen one Indigenous community, right? So that speaks to the diversity of communities, the diversity of interests, and you even talk about the diversity of rights, right, in relation to each of those communities. And then you match that with this kind of diversity of all these projects that potentially could come forward, lots of complexity there. So what kind of impact do you think that level of diversity of interests and frankly representation would have for Indigenous involvement in the corridor project itself, either as potentially a member of a federal commission or participation upfront and actively, or participation as a proponent? What impact does that have for Indigenous groups?
Yeah, well, I mean, all of the above, really. I think the important starting point would be to start at the principled level, right? And so the process would, first of all, have to be set up. It's into sort of this is less like duty consult doctrine and more into political economy and the governance side of things. And again, there's this paper that's just been released as part of the project that I was not involved with. But a collaborative development of the process based on principles of mutual respect, good faith interactions, nation to nation dialogue, understanding of where clarification of rights and interests may fit within the process or in a parallel process. Those are all the key starting points so that Indigenous communities can see and understand that this is not merely merely a transactional endeavor, and it's not necessarily an efficiencies mindset. So that's going to take a whole lot of different forms depending on the rights, interests, and desires of Indigenous communities. So in some contexts, that could be that Indigenous communities want to be proponents, and I can't sit here and speak for that notion. Or in other contexts, they may simply want to participate in that context. Either way, in some ways it's the flavor of the month, but it's kind of rightly so. The way forward is a collaborative approach, and it really is up to Indigenous communities to decide for themselves how they want to engage, how they want to collaborate, and it's up to the Crown to approach that with a very open mind. And good.
That's the basis, right, of a two-way engagement, a two-way communication, and a two-way collaboration, right?
That's right. And just to add to that last piece there is, we didn't talk about where the proponents fit in there, but one would expect that potential proponents would be heavily involved in those discussions as well. Again, building relationships and again, keeping an open mind.
David, one other concept you raised in the paper that remains an area of uncertainty, and I'm hoping you can comment more on it, is the area of consulting on legislation. You talked about that as being, potentially an area where there's still evolving responsibilities in case law, and potentially has an impact on the corridor if it becomes a kind of legislated right of way, or legislation is used in some other way. So can you comment on that?
Yeah, I'll do so succinctly, largely because the law is still evolving and is uneven in that. The Mikisew case from 2018, maybe 2019, had several decisions within it. It's a tremendously complicated judgment from the Supreme Court of Canada, but the upshot is that the duty to consult is not necessarily triggered by the legislative development process. Rather, once the legislation is in place, if there is some kind of impact on Indigenous rights and interests, a lawsuit may be able to essentially overrule that legislation to the extent that it offends Indigenous rights. However, the court, most justices on that divided court agreed that consulting in the legislative development process is good practice. And there are a number of examples of this across the country. Most notably, we've already talked about the NWT, but it's a good example of this. So the NWT, it's imperfect, but the Northwest Territories has done a reasonably good job of working with Indigenous communities early on in legislative development processes to so-called co-develop. So picture in real terms, this is legislative drafters from the government working with Indigenous organizations and their representatives to try to reach legislative text that strikes the right balance. So that while the legal requirement to engage in that kind of process is unclear in today's case law, there is direction or guidance from the court that it's wise to do so to the extent possible.
Yeah, you bet. Could you just in closing give us your thoughts on what additional research might be beneficial in this area as this overall research program moves forward?
Sure. There's no limit to it, that's for sure. I mean, I think not a lot more research can happen until the potential legal forms of the corridor are clarified. So Therefore, a logical next step would be to look at, what different legal forms could this take? Is it some kind of legislated national corridor statute, a special, Cross-Canada Infrastructure Act? And if so, what does it establish? Is it just a right-of-way in principle, or would it actually include some kind of initial route clearing, and so on? And so the idea would be to try to make it less abstract, so that one could do more legal analysis to understand what consultation obligations would be required. And that also would put, again, those who are looking to pursue the concept in a position of being able to have more meaningful early conversations with Indigenous communities along the route, be they in relation to consultation or uncertainty of rights and interests in jurisdiction or potential commercial involvement and so on. And so, yeah, I think a logical next legal research step would be to look at the possible legal forms it could take. Related would be what institutional, and this is where the governance piece, I think, takes a step in the right direction. What are the institutional arrangements that this could take? Is it a Berger Inquiry 2.0? Is it a Crown Corporation? Is it all of the above? To what extent does it include proponents, and so on? So it's kind of two main streams there.
Great, thank you. Well, that is all the time that we have today. Thank you so much, David, for, again, a fantastic presentation, a really interesting paper that I would recommend folks take a look at, and just a great discussion today. So thank you so much for that. As David did mention, and we referenced it several times in this discussion, we do have another paper that we want to spend some time digging into. We've got a webinar scheduled for Thursday, December 10th, where we will look at the paper called Governance Options for Canadian Northern Corridor. And I expect we'll have a really lively discussion and exploration in that webinar. So I'd encourage folks to tune in for that. Thanks everyone for joining us today, and I wish you all a good afternoon. Bye now.